It is the third week of November, which means it's monthly momentum. So, for those of you who are curious about what the heck is this monthly momentum that WREN does, every third Wednesday of the month, we open it up to a guest speaker. Sometimes it's one of our sponsors, sometimes it's a person that we are building a relationship with that has lots of great information to share. And in this particular case, has anybody not heard me talk about how much I'm in love with the Bell Alliance team and our new lawyer, Richard? Like, I think everybody, Richard, people are already tired of me saying, I love my new lawyer. And I just like, can you even say that? So I'm probably going to make him blush, but I'm
No.
just like, I've never met a lawyer who is so unlawyerly. And the things that he does, the opening the schools, the building homes, like we've just every time we meet, I feel like I'm in the presence of like this sounds crazy, but I feel like I'm in the presence of a real life Santa Claus. So it's just been
Or
so
just an old
fun.
guy with gray hair.
Just, oh my gosh, you're so much more than that. So I'm so excited to be building this relationship with Bell Alliance. And I know a couple people have already talked to Richard and they're like, okay, yeah, we get it. His reputation is just like, yeah, everybody highly recommends Bell Alliance. We're super excited to be working with them. And Richard and I have been having some conversations, and we are going to keep things very busy in the new year. And a lot of the things that Richard is passionate about are things that we're passionate about and that are really lining up nicely with the timing, right? The sixplexes, the eightplexes, the rezoning, the small works that he's going to talk about probably next time, the legal structure. Like there's so many different things. So we're super, super duper excited about that. And I know there's some things that he kind of has told me a little bit about on the side as well that we're still waiting to hear if those go through. But new mortgages and Royal Bank coming up with a new mortgage product, Advanced City coming up with a new mortgage product. So all kinds of exciting things. So super excited about Richard. And I also just want to give a warm welcome to our newest sponsor who I've mentioned, Mortgage Pal. Jen is here. So Jen and Darcy are going to start seeing a lot more about and we've got some programs that we're working out with them as well.
Okay, just a bit of background. Bell Alliance. I'm the founder of Bell Alliance. We do only solicitors work. We like to say we practice happy law. Our standard of care we're dealing with our clients is based on how would you like your mother to be treated? I take care of my 96-year-old mother. She's been living with me for 6 years. I have moved from one level of patience to a higher level to a higher level to a higher level as she ages and has her challenges in life. I have the family compound. I have 4 generations living on a piece of dirt in Vancouver. There's the family, including my 70-pound out of control dog. And so I've got 2 granddaughters, 2 daughters, son-in-law, and that's my 96-year-old mother in the middle there. We live just off of Cambie Street. My property was redeveloped under a co-ownership model, which means my kids and my son-in-law are owners of the property together with myself. We refinanced the property to enable the development of the property. The ultimate challenge of anybody that's been investing together with other partners in a co-ownership model is there is one legal description and therefore one mortgage on the property, which everyone becomes 100% liable for in terms of debt service ratios. So even in my situation, I get a call one day from one of my daughters going, Dad, I'd like to buy a new car, but I don't qualify for a car loan because she's 100% responsible for the mortgage. So Dad decides that he's going to buy a new car that he has never driven. So, within families, you can make that work. But even then, there's challenge. What happens if the aging parents need to go into care and their co-ownership interest is where they have a significant amount of their wealth? So there's the reverse scenario where a parent may say to the kids, this has been great, but guess what? We have to sell the property in order for me to be able to pay for care. It doesn't, that's not necessarily a problem for some families, but for a lot of families, it would be a problem. So this slide here is just talking about this multi-generational, it's a big issue. It is probably the number one sort of change that we're seeing is families saying, how do I help my kids? They may give them a couple $100,000 to buy a property, or more and more they're looking at how do we redevelop their existing property, building multiple units on it. So this is so I sit on the board of Small Housing BC. I'm just the most recent past chair. That organization has been around for 10 years. We've been the major organization that has lobbied both municipalities and the province for what we refer to as gentle densification. We were working hard with some success, and then we were really pleased when David Eby stepped in and the government announced that the cities were going to have to allow gentle densification up to 8 units. And this isn't just a BC scenario, this is global. New Zealand was one of the leaders in this. They imposed national legislation requiring 3 units. Still a bunch of problems around this, but the stratification is absolutely critical. You see the note here, Ontario's moved ahead as well on this initiative. The province has basically said to every municipality, you must allow for densification of the property. Some municipalities, like, surprise, surprise, West Vancouver, was a little unhappy with what they were being told to do. In part, I think that in the back room, a lot of the municipal politicians were going, vocally, I'm going to be upset that the government's doing this. Privately, I'm going to say, thank God they're doing it because we need to do it. Now we, as the municipal politicians, don't have to take the heat for this gentle densification. And there's issues around parking and there's issues around infrastructure, but the good news is that this brave move was taken by the provincial government. Vancouver actually passed their bylaw amendments before the legislation came down. I expect they could read the writing on the wall, and they wanted to provide that leadership. So that's the big change. Separate titles. Okay, so if we look at some scenarios, my situation, my kids would have owned their own strata unit. They would have had their own mortgage on the property, and that would have been great. A couple of sort of scenarios, including the investor side of it, but the other area that I'm involved in is working with families where they've got adult disabled children, adult children with disabilities, and looking at some of those families coming together, and while they're still alive, building a complex where their adult children could move in. Perhaps there's a small unit for caregivers. Similarly, investors coming in to buy a property. I've got some inquiries right now out of a fairly significant company out of Mexico, Liza, who are looking at, they want to get some money into Canada, and the foreign buyer ban doesn't apply to foreigners if they're redeveloping property. For just investors in general, this makes a lot of sense for them to be able to say, why don't we come together, build 4, 6, 8 units, and then you've got, instead of having one investment, one condo in that building over there and another condo in another building, you've got property that all the units are together. The other advantage is we've got provincial legislation that deals with strata. Now, what Small Housing BC is now working on is having the government make amendments to the legislation that specifically deals with these smaller complexes. Right now, small stratas are viewed as non-conforming, so we want to make changes there. Liza mentioned about financing. Van City's always been creative on financing. They're probably, if anyone was doing a laneway, you would automatically go to Van City. RBC's stepping up because of their acquisition of HSBC. The federal government has required that they provide financing to deal with this affordability issue, and RBC's in discussions with Small Housing BC as well as a company called Small Works about offering that. And so, Jen, one of the issues we're going to be is, which of the other lenders come along? I mean, once you've got Van City and RBC, the other lenders are going to follow together, so that the ones that work with mortgage brokers will go down this path. I'm going to just take a quick glance at this slide here that's showing right now to see whether there's anything in particular. The last comment on this page on estate planning, one of the problems with co-ownership is, what happens if there's 3 kids and one lives in Toronto? How do they participate in the co-ownership scenario? Again, what Strata does, it makes it much easier. That child living in Toronto could become an owner of one of those units. They could then have a rental property. So again, they get the same benefit of the fact that they're now an owner of a piece of dirt in a building in Vancouver or wherever that has a tendency to increase in value. And so there's less of a requirement for us to get a complex estate structure in place to try and equalize between the children. Yeah, when we've got co-ownership, you have all those issues. Okay, so what unit are you occupying? What outdoor space is yours? And so basically the way we look at these is very much when it's co-ownership, we look at it as if it was strata. We say, okay, here's a plan attached, sketch plan. This is the area you get exclusive use of. This is the common area. The bigger challenge is, who's cutting the lawn and who's doing this and who's doing that? And, are you really going to pay for someone to do it? And you do have to manage family dynamics or friend dynamics because someone always tends to be doing a little bit more than the others. And that, people have to accept that that's going to take place. Yeah, so in the finance considerations, I think we sort of looked at that. The last bullet here around capital gains, there are some issues around that where it's not stratified. So we see a lot of laneway development. That potentially, from CRA's perspective, is a separate asset. They treat it as if it was strata. So if anyone ever sells the property, there will be a capital gains on the laneway. But that's sort of a discussion with the accountants. This I thought I would just throw out, and whether it's co-ownership or strata, this is just an example of some of the numbers that would be required. So thought some of you would likely be interested in investment opportunities, and you'll get copies of these. So what happens if they want to do 3 or 4 units? What's the equity requirement? What's the income requirement? And this just gives you some numbers around that. When we have a follow-up meeting with SmallWorks, SmallWorks has built more laneways than anyone else in North America. They're now expanding their operation to respond to this new legislation that's going through, and they'll be able to work with clients for the financing, the zoning requirements, all of those different things. One of the challenges just mentioned in terms of financing that we're going to see unfold is that a lot of the construction on these are going to be done off-site. Okay, so we're already seeing the feds are going to introduce pre-approved plans. Provinces introducing pre-approved plans. So essentially what will happen, you'll be able to look at a piece of property, you'll be able to go on either the federal site or provincial site or municipal sites, and you say, okay, I want to build 6 units. And they'll be, okay, here's 5 plans that apply to those 6 units. If you select one of them, you'll get your building permit right away. Well, what we'll see unfold over the next sort of 24 or 36 months is more and more off-site construction, because off-site construction becomes a lot simpler when you can preset everything based on preset plans. So quite frankly, I think we're going to see, I have this vision in 36 months, you'll press the button, you'll get your permit, the data goes off-site, the robots are working, putting it together, and 60 days later you move into your home. That's my vision. It's what, and I don't think I'm smoking anything funny now. Perhaps a few years ago I would have been, but So that's a real game changer. It's a tremendous opportunity for investors now that they're going to be able to stratify properties. Um, so I think this is just another example, which again you will get, which again talks about, what happens if if you're building 3 units or if you've got equity in the property. So it just is really helpful for someone to get basically a general sense of what's the financing going to be all about. The challenge, and interesting enough, as we go down this road of offsite construction, the lenders have to be really creative on their financing, because what they normally do, of course, is you get construction draws. There's the property, the house is going up, we're now at lock up, and so we advance more money. Where when all of a sudden, 90% is built off site, they have to really sort of look at different options for financing, which they will do. This is a game changer. This is a generational shift in densification. And I think the extreme one is what Vancouver did, actually. You don't actually need any on-site parking under Vancouver's new bylaw for densification, which is quite surprising. And their basic belief is, and I think they're probably right, I don't think my grandkids are going to ever drive cars. I think they'll just order a driverless car, and Waco, who's operating in San Francisco, will be up here in no time with driverless cars. So, Lisa, do I have? Yeah. So that's a lot of information, I know. Don't hesitate to reach out to me with any questions. You will see so much of this unfolding. Right now, there's a few people that are sort of aware of what's taking place. Multi-generational is leading the charge. Investors, I think, are going to come in fast to do this. There's not a lot of margin in building and selling, but there's great opportunities for holding, for rental, and then the values increase over the way it's designed is literally as it's a product that's saying a lot of developers aren't going to have a big enough margin to build and flip. But investors have that longer timeline that they're working with, and it's such a great opportunity for a few investors to come together. So I have to leave, because I have to leave early every day, because I got to get home, feed my mother. If she doesn't get fed by 5:30, she's not a happy person. So, as I say, don't hesitate to reach out to me. It's great being involved with Liza and the folks that she's working with. And I will turn this over to Elisa now, and she's got lots of information on estate planning. Get it done. Bad things happen to somebody. So just make sure all your stuff's up to date.
Richard, thank you. I know you have to dash off, but just before you mentioned the robotics thing, I wrote in the chat, AI robotics building 24/7 and delivering flat packs not too far down the road. So I wrote that, and then you talked about robotics. So we know it's coming. And yeah, I think, when you and I chatted, we talked about the application for our group, for like the vast amounts of single women. It's going to be easy to get your sixplex together and call it your retirement home. It's also going to be easier for women to get together and have that as their first entry into investing. Rather than buy a condo, get a group of people together and do this instead. It's going to be that nice long-term hold that you can use towards your retirement, and you're providing great housing for the community. So we see it as being very much a applicable situation for what we're doing with our WREN group. And it works great for women, works great for retirees, works great for the multi-generational. Love it. So I know we're going to be talking a lot more about it with Small Works and all of the rest. So thanks for the quick introduction. We're going to build up to giving a lot more information in the new year. So I'm super excited about it.
So I just got back from Cambodia, so I'm doing so much more of this nowadays, right? And I got to tell you a quick story about our project in Cambodia. I arrived at this new gated community where we're moving people out of the slums, and there's this 5-year-old, 6-year-old girl comes running out of the community, and I realize she's running straight at me. She comes straight at me, and she leaps into the air. Fortunately, as a grandfather, I knew what to do, and so I grab her, but what a great moment in time. So, ladies,
Love it.
pleasure. Talk to you all soon.
Very cool, right? So I think there's, just a quick introduction because there's lots of opportunities there. The Crescent property that a group of us bought, the 8-unit apartment building. It's kind of an interesting case study, and it'll be interesting to see how we take what we did there and apply it to some of these new things that are coming out. So I'm really excited about it. And so, Elise, it's over to you to talk a little bit more about wills and estate planning. And it's Financial Literacy Month, November. It also happens to be Entrepreneur Week this week. So we're kind of like reminding people there's so many of us that have small business that don't kind of talk about or get these things done or put it on the back burner. And when you've got corporations and other people to be involved in your whole plans, and you're traveling a lot, we got to get this stuff done. So let's get this offer list for 2024 so that for 2025 we start with a nice clean slate and we can start diving into all of these exciting projects. And we also can go to Rwanda with Barb, and we don't have to say, oh, I can't make it because I haven't got my will or my taxes done yet.
Perfect. Thanks so much, Liza. Firstly, I just wanted to say I am so thrilled to be here. So thanks very much for the invite and the introduction. I work with Richard. I'm a lawyer at Bell Alliance. Richard does both estate planning and does some work with residential conveyancing. I strictly do estate planning. So this is what I know and what I love. So my plan today is just to run through sort of a high-level overview of the key estate planning documents. But as Richard said, we're very approachable, very friendly. So if you have any questions at all afterwards, please feel free to reach out to either of us because we're always happy to take a call or a question. Okay, so I'll dive right in. So a will, hopefully all of you know as a good starting point. So this is the document that governs what happens when somebody passes away. The key for this document is that it only takes effect on death. So a person will write it. So a will maker writes it during their lifetime, but it has no effect until death. And the funny thing, we always chuckle a little bit because we do get calls from executors or beneficiaries who have been appointed in a will, and they're asking, well, can I do this, or what happens with this? And the will maker's not even died yet. So we always have to politely sort of say, look, great, you're so interested in what's going on, but really we can't guarantee that the will won't be changed beforehand. So there's nothing we can really assist you on at the minute. Wherever you get a will done, there's no sort of prescribed form, but there's generally some key clauses that are present. So the first is an executor clause. So that is really the person who's responsible for administering the estate. It is a huge responsibility. So we are seeing increasingly a request for independent trustees or executors. Bell Alliance sets ourselves apart a little bit because we offer that service whereas many law firms don't. But there's also other corporate trustees, like trust companies. All of the major banks usually have a trust arm, and also there's some independents in the city as well. But family members, friends, they're all good options. What we generally recommend is that you appoint someone in your local jurisdiction, because there can be inadvertent tax or disclosure obligations. So whatever province you're in, that's sort of the first choice. Canada is fine. Just practically speaking, there might need to be some travel. But if you're wanting to appoint an executor, for example, in the US, that does cause a little bit of an issue sometimes and further afield. Another clause that we generally include is guardianship for either minors, and we do a lot of pet guardianship clauses as well. So anything that you can think of in relation to your pet. So we've created clauses about sort of regular payments for vet bills. We had one pet who sort of had a very extensive trust fund set up for it, so it could continue its lavish lifestyle. So it's, your loved ones are, regardless of whether they're individuals or furry friends, we can provide for them in your will. Specific gifts and cash gifts. So Cash gifts is pretty obvious. So if there are specific amounts that you want to leave to individuals or charities, for example, that can be incorporated. Specific gifts relate to specific items, so personal items or referred to as articles sometimes. They can either go in your will, but oftentimes we discourage against specifically noting it in the will, just because you might give it away during your lifetime. Things can change. You might fall out with the individual that you've left it to, and that would require a formal update to your will, which obviously takes time and is costly. So what we generally recommend is something called a letter of wishes or a memorandum, which is a non-legally binding side letter, which essentially provides moral guidance to the executor. So you could have a whole host of assets that you would want to go to certain individuals, like jewelry or artwork or whatever your heart desires. And then it's for the executor to check whether you have it at the relevant time and then give it to those individuals. Residue is just a fancy word for net pot at the end. So after all of your taxes and liabilities have been paid out, where do you want your assets to go? So the most common types are outright gifts, so there's no strings attached, or trusts. And we do a lot of trust planning within the wills if there are minors, also if there are persons with disability, because we don't want their government benefits to be affected. And increasingly, especially in the Lower Mainland, we've been addressing sort of addiction and mental health issues, which we can utilize a trust to protect. Lastly, administrative provisions. So this is really the toolkit for your executor to be able to deal with your assets as you would. We don't have a crystal ball. We don't know what the situation will be when the person passes away. So we throw in a bunch of powers for the executor and trustees to utilize if they need to. Not all of them are relevant, but just from experience, we've included what we think is relevant. One point I did want to touch on, especially because there are a lot of business owners in your community, is that, well, in British Columbia and in some of the other provinces, there you can utilize dual wills or multiple wills. And this is a special structure where you can have two wills, one for your corporate assets, as long as they're shares in private companies, and one for your non-corporate assets. And the non-corporate asset will essentially governs what happens to those assets passing through probate. The non-corporate asset will is disclosed to the court. And so there's a little bit less privacy in relation to the non-corporate assets. The corporate asset will, if everything's done correctly, it doesn't go through probate, which is, I'll talk about in a minute, but is essentially just a court process. So there's a little bit of privacy there, and also there's no requirement for a grant of probate, which again, I'll talk about in a minute. But really the only reason to have a dual will approach is to save on the probate fee, which in British Columbia is about 1.4% on the gross value of the assets passing through the estate. So generally speaking, we suggest that estate plans are reviewed every 5 to 7 years. And again, we try to set ourselves apart. So every 5 to 7 years, we reach out to clients by email and just say, hey, these are the documents you signed a few years ago. Are they still relevant? Just as sort of a reminder to have a think about everything. And I've just listed some of the major life events which should trigger a thought as to whether the estate plan needs to be updated. And one other life event that should have been on the list is a change of jurisdiction, because that definitely will affect the estate plan as a whole. So just briefly, intestacy. So this is what happens if you don't have a will. So the provincial government essentially dictates how the assets are distributed, and it really depends on what family members are alive at the relevant time. So I've just put some common scenarios in relation to British Columbia. So if you're married or in a common law relationship, but there are no children, the default is that everything goes to the survivor. Number two is what really confuses people. I often get asked, well, everything will just go to my spouse or common law partner, even though they have children, and that's not the case. So just to break it down a little bit, if you pass away and you have a spouse or partner and children, the spouse or partner will get all of the household furnishings. They will get a preferential share, and that depends on whether your children are all in common or if there are children from outside of that relationship. So if all of the children are in common, then the spouse or common law partner will receive the first 300,000. But if all of the children are not shared, then the preferential share drops to 150,000. And then everything over and above that is divided equally. Half goes to the spouse or common law partner, and the other half is divided equally between the children. So there's no ability in the intestacy rules to put trust terms in place. So if there are minors or persons with disabilities or other considerations that need to be taken into account, those individuals will receive outright without any strings attached. Also, it's important to say that the public guardian and trustee, so there's an equivalent in all of the provinces, they often need to get involved if there is a minor or person with disability who's inheriting, because they will essentially take hold of those funds. And then there is a separate process afterwards that can be used to transfer to a family member, for example, as a trustee. But it is very lengthy, and yeah, it's costly. So it's best to avoid if possible. I also wanted to touch on wills variation. So again, this is from a BC perspective, but there are various different equivalents in some of the other provinces. So basically, you are free to leave your estate to whoever you want. However, it's caveated because a spouse or common law partner, as well as children, whether those children are biological or adopted, can make a claim against an estate if they feel like they've been inadequately provided for. So what a lot of people don't realize is that when somebody passes away, as part of our probate process, which again is just the prescribed sort of court process, we have to serve notice on anyone who is named as a beneficiary in a will, but also anyone who would have a claim under the intestacy rules. So if you cut out a spouse or common law partner or cut out a child, they will still receive notice and a copy of your will, for example, on your death. So it's really important that if these are considerations, that legal advice is obtained, because there are ways to help mitigate. So at the bottom of the slide, it just shows some of the common techniques we use to help mitigate a wills variation claim. We don't practice any sort of litigation at this firm. I'm surprised Richard didn't say this at the outset, but we only practice happy law, as he likes to say. So we try our very best to avoid any conflict, but we can't take away the wills variation right of an individual. So we help to prevent it, but if it does take that extra step and go to litigation, then at least we have some real documentation in place to help protect the will maker. So the first thing is pretty common sense, but open communication. I think it's perhaps a generational thing, but a lot of clients we see, when their elderly parents pass away, they have no idea what's in the will. They have no idea about the assets. They have no idea about who's set to inherit what. So it would help if the parents had at least talked to the children or explained why they had distributed their estate in a certain way. Obviously, there are very legitimate and valid reasons to provide disproportionately. I put on the slide, for example, one child is at home caring for an elderly parent, while another child is perhaps living abroad. So it would be helpful if we had that sort of written down instead of making all of these assumptions after the fact. If we know that there's a potential for a wills variation claim, even if the family gets along really well, we do include a generic sort of wills variation clause within the will, stating that the will maker knows about wills variation, but they still are choosing to distribute their assets in this manner. And then we will also prepare a supplemental wills variation statutory declaration, which basically outlines all of the reasoning. So it won't be produced to court during the probate application process, but if a claim is made down the road, we have a document that was signed by the will maker while they were alive confirming the reasoning. So the contemporaneous evidence is key in these sorts of situations. And lastly, I just wanted to touch on alter ego trust and joint partner trust, and I'll go through this a little bit more in a few minutes. But these are very specialized trusts. There are certain restrictions, so you have to be over 65 and a Canadian resident. Oftentimes, clients use this sort of planning to mitigate probate because those trusts bypass the probate process. But it's not the only reason that these sorts of trusts should be put in place. And one main reason is to mitigate a will's variation claim, because the trusts themselves are very hard to penetrate and are not subject to the will's variation legislation. Okay, so just briefly, so probate, as I said, is just a court process. It validates the will and appoints the executor or the administrator if there is no will. The document that's produced by the court is called a grant of probate if there's a will, a grant of administration if there's no will, but the general sort of umbrella term is representation grant, and it's very underwhelming. When we get it back from the court, it looks like a photocopied document, and there's a photocopy of the will attached to it. The court actually keeps the original wills, which does upset clients sometimes, but that's their process. The grant of probate is really your golden ticket. So that's what's required to transfer ownership of various assets. So for example, the financial institutions will generally require it. ICBC will require it. Transferring land, the land title office will always require it unless it's obviously held in a company or as joint tenants, there's certain exclusions. But as I mentioned before, private company shares or other sort of personal possessions that aren't registered anywhere don't always require a grant of probate. So there are ways to structure assets to help sort of mitigate which assets go through probate and which assets do not go through probate. At the moment in British Columbia, there's a $200 filing fee when making the application. And as I said, the probate fee, which is payable to the provincial court, is about 1.4% on the gross value of the assets passing through the estate. So probate itself there's so many rumors and misconceptions about probate. It can take as quick as sort of 4 to 6 months, I'd say. At the minute, the probate registry is very behind, so it's taking about 4 months to process applications, but we have had them processed within a month or two when they're sort of up to speed with everything. But I also have estates I'm working on where it's sort of 2-3 years deep, and that's because there could be various issues that arise. So at the bottom of the slide, it just outlines some of the potential complexities that occur. So if there are executors appointed, or if there's more than one, do they get along? Where are they located? Are they willing to act? Are the appointed individuals incapacitated or are they deceased? The number, the location, and the type of asset. So are they in BC? Is everything in real estate so there's no liquid funds? Are they outside of Canada? Number of beneficiaries, do they get along? Are there minors? Are there trusts? Are there persons with disabilities? Family dynamics always comes into play. So you can see it quickly snowballs. Everyone comes in and says it's very simple, but when we start to unpeel and actually look at what's going on, sometimes it's not so straightforward. So just in terms of mitigation of sort of probate during lifetime, there's a lot of things that can be done. So one thing is lifetime gifting. This could also be sort of used simultaneously with loans. But the overarching key is that there needs to be documentation showing intention. So is it a true gift, or was the parent just adding their child onto their bank account for convenience purposes so they could go in and do some of their banking? We see that a lot. So what is the child the actual beneficiary of that account, or are they holding it technically in trust for the rest of their siblings? I just put a case on there. This is Pecor versus Pecor, or and PCOR. So there are some presumptions that we always bear in mind when we're looking at gifting. So if a spouse or common law partner, if they are together on an account or an asset, the presumption is that it's a true gift and they're meaning to benefit each other. However, if there's a parent and an adult child, for example, the presumption is that the child's holding it in trust for the parent's estate, unless there is something to rebut that presumption, like a deed of gift or a declaration of true joint tenancy. And all of these sorts of documentation is what we discuss with our clients and put in place to make it absolutely clear what the intention is. There's a very funny English word on there called hodgepodge, which I'm not sure many people have heard of, but that's really an equalization on death. So if, for example, a parent has given one child, I don't know, $200,000 during their lifetime, but didn't have the opportunity to give their other child or other children an equal amount, then we would put a hodgepodge clause in the will to say, for example, the child who received that gift should receive $200,000 less on death, and the child who hadn't received those funds should receive $200,000 more in order to equalize. But again, it's really just important to document everything so that there's a clear intention. This slide, there's a lot of information on it, and basically we just created it so that we could summarize some of the key estate planning options that are available. Sometimes we have to use multiple scenarios or options, but it's really just to highlight the pros, the cons, the considerations. So multiple wills is just the dual wills, which we talked about. Alter ego trust and joint partner trust, again, we did touch upon this. You can see it's the most costly option to set up. So there really has to be a strong reason, like probate mitigation and wills variation and sufficient amount of assets to warrant that being set up, because there are ongoing costs such as accountancy fees, and there's other disclosure obligations now that come into play. Bare trust, so we used to see a lot of these. There was some confusion. You may have noticed earlier in the year with the CRA requiring sort of filings and then reneging on that. But a bare trust is essentially when the legal title to an asset, so those who are on the account or on the property, are different to those who are the actual true beneficial owners. So the bare trust resulting trust, that's when, for example, a parent might be on title with an adult child, but they're holding it in trust for the parent's estate, for example. Bare trust with gifts of right of survivorship. This is an interesting one, and there are some financial institutions who have special accounts that have this ability. And also we sometimes do this in relation to property. So if there's a parent and they add a child onto legal title, for example, there'll be a gift with right of survivorship underneath, saying that the parent is the true joint owner during their lifetime. So if the property's sold, for example, then they can do whatever they want with the funds because it's still theirs. But on their passing, the child would inherit it by survivorship. There are obviously risks associated with adding someone else onto legal title, as well as sort of tax considerations that need to be thought through as well. True joint tenancies. So this is really adding someone onto legal title to the account or the property. We get asked a lot, should I add my child or should I add this person onto the asset in order to avoid probate? Really important to bear in mind that that asset then forms part of any marital breakdown. So claims for during a family law claim, creditor claims. If it's in relation to a principal residence, there might be some loss of principal residence exemption. So before you do anything, make sure to speak to a legal advisor and also the accountant or your accountant to see whether it is really worth doing. Probate generally is annoying, but sometimes it's a lesser of many other evils. So it's just worth keeping things a little simpler for sanity reasons. And beneficiary designations. So the beneficiary designations can be made on registered accounts. So those are your RSPs, your TFSAs. some other pensions, and life insurance proceeds. So those assets do not fall into an estate for probate purposes as long as they have valid beneficiaries designated. I would just be mindful not to name minors or persons with disability unless there's a trustee also associated with those designations. And for the most part, there are no trust options, so you can't have the funds flow through a trust unless a special type of like life insurance trust is set up, for example, which isn't warranted in most of the circumstances. So if that's the case, then it might be better just to have those funds flow through the estate, but it's very sort of circumstantial and case by case. Lastly, I just wanted to touch upon some of the advanced care planning. So it's really important to note that this is very jurisdictionally specific. And I'm not talking Canada. So every province does things a little bit differently, which is very frustrating. But if we have someone, for example, come from Ontario or from Alberta, and they retain assets in those jurisdictions, we generally recommend that they put a power of attorney in place in British Columbia, but we are careful not to revoke their Albertan or their Ontario power of attorney because they'll need to use them potentially simultaneously. So powers of attorney and representation agreements, these documents are only applicable while you're alive and they cease on death. Power of attorney relates to property, finances, and legal affairs, and a representation agreement relates to health and care decisions. So the power of attorney is obviously a very, very powerful document. So it's really important to appoint people you trust. And there are different types. There's sort of a general enduring power of attorney, which is essentially effective from the point of signing, or there's something called a springing power of attorney, which comes into play on a triggering event, which is generally an incapacity. So there's a lot of things to consider when putting the power of attorney in place. And just like with the executorship, it's best to appoint someone in your jurisdiction. Definitely appointing a US tax resident causes a lot of issues. Section 9, I just wanted to touch upon the different types of representation agreements. So a Section 9 representation agreement would relate to health and care decisions where the person who's putting the document in place has full capacity, understands what document they're signing, what authority they're giving to individuals. But if there's any diminished capacity, so they still have some ability to understand, then we would put what's known as a Section 7 representation agreement in place. And that would only allow for sort of routine financial decisions and some healthcare decisions. So the Section 9s are very fulsome and provide a lot of power. Section 7 is slightly reserved. And then the committeeship, some people pronounce it committeeship, is really when there's a total lack of capacity. So that requires a court application and someone to be formally appointed by the court in order to deal with finances and health decisions. So as you can imagine, it's quite lengthy and costly. So we always recommend, as part of a sort of fulsome estate plan, that powers of attorney and representation agreements are put in place, if nothing else, as more of an insurance policy, just so someone doesn't have to apply to the court in due course. And I think that is all I wanted to say. Don't know if there are any
Amazing.
There's a lot of information.
There's a lot of information, but the interesting thing is like, as you were going through it, I was thinking about all kinds of different times, people, applications that I know have been impacted or need to get these things done. Or like I lived with a woman who had dementia, and so she had someone who did, they did the representative agreement while she still had all of her faculties. So it just made it much easier to manage her, her 10 years as she was going downhill with her health. And it just made it easier. Like it's just, and I'm always curious, and I don't know what the stats are, but it'd be interesting to see what the stats are for how many people who don't have these things, right? Like, okay, it's one thing if you die without a will, but if you get hit by a bus or you've got Alzheimer's or dementia and you're losing your faculties, to not have someone who can manage your affairs just seems ludicrous. Like it's It's
It
crazy.
comes up a lot. And one of my colleagues, her practice predominantly at the moment is just going to court for these commutateship applications. It's becoming increasingly prevalent, which is scary.
Yeah. Yeah. Lots of mental health. We're living longer, but our quality of life isn't necessarily, right? Like a lot of people are living 30 or 40 years with a severely diminished quality of life. And if you don't have all of those things done in advance, the time, the cost, the stress, like it's one of the reasons why I thought, like, let's just start getting this out there now, because we can start working on it, and it's going to take some time, but start working on it because it's so important. I've been trying to get my mom and my sister to sit down and get all three of us to have a representative agreement. I think we're moving into year 3 that I've been like saying, can we please just get this done? So I'm hoping that now I can, share this with them and get that done in the new year, because
absolutely. And
it's
I think
procrastination thing, right?
It is. And historically, it was reserved for sort of a certain sector of the population. But part of my mission is to make sure that everyone has these documents. I mean, I encourage my friends, my family. It's really important to get these in place when you're younger, because then it just becomes part of your life and it's routine. And every few years you update it as your life changes. We get so many calls when people are in the hospital or something has happened which prompts them to need this, and it's much better to have the time to think about it instead of reacting to something that's happened.
Yeah, exactly. I had a situation where my stepbrother's his dad was dying, and he was literally in the hospital, and he didn't have much, but he wanted to make sure that his son got it and got it as quickly as he could. And so Shane flew out from Toronto, and literally, like, the lawyer basically wrote up a document and said, if he can sign it before he dies, then you're okay. And literally, he basically came into consciousness for about 5 minutes while he was in hospice, managed to get this thing done, and it made made his whole life easier moving forward. But it was just, it's the things that we put them off, we procrastinate, we forget about how important they are. And so, I think it's super important. So Hong's got a question. At what point do we consider bare trust with gift versus true joint tenancy versus JP trust versus AET? Big question there. There's someone who has lots of properties, right? It's like, and we've got corporations and joint venture agreements and property here in this province and property there in that province.
That is a loaded question. I think it depends on what you're trying to achieve and your assets and who you ultimately want them to go to. I generally discourage true joint tenancies unless you are prepared for that person to be able to deal with that asset. And I mean, worst case scenario, they do something they shouldn't do with that asset because they have total authority and right to deal with the asset. Alter ego trust, as I said, you have to be over 65, so it only affects a certain sort of section of the population, and you have to be Canadian resident. And we generally, unless there's a very strong case for like wills variation, we generally don't put them in place just to mitigate probate. And probably, I mean, with any trust, it depends on the situation, but it might not be worth it sort of under 2-3 million. And sorry, the bare trust, again, it depends on what the ownership structure is at that point and what you're trying to achieve. So did you buy a property in your sole name because that's what the situation was, and now you want to add someone else and you're trying to mitigate property transfer tax, or what's the real reason why you want to change the underlying sort of ownership?
That sounds like a phone call between you guys.
Yes, I'm very happy to answer any questions.
Yeah. That's awesome. Very cool. And just for the benefit of those who maybe haven't heard the term before, what is an alter ego trust? Because that's not something that I think everybody has heard.
Okay, so the alter ego trust is for an individual. A joint partner trust is the equivalent, but that's for partners. And so you have to be over 65, you have to be Canadian resident, and we're not entirely sure why the government allows it, but it's a special type of trust where the person settling the trust, which is you, the person over 65, for example, can benefit from everything, so all income and capital during their lifetime. but then it's sort of like a pseudo will, so you can dictate what happens to those assets after you pass away. So it does provide protection from the probate process, wills variation, and provide some certainty as to where your assets will flow.
Okay, awesome. Terrific. Okay, does anybody have any questions that are easily answerable on a Zoom call? Because now you know that Bell Alliance is going to be doing a lot with us in the future, so I'm sure there's going to be lots of phone calls to you guys in the next little while. Hopefully, there's either phone calls from the group, or people in the group are going back to their families and friends and saying, "Hey, have you got your will done? Hey, have you got your representative agreement done? Hey, how's your power of attorney? Do you need one? Like, I'm going to Mexico for 2 months and I know I've got some things that are moving around, so it's going in to sign my power of attorney document on Friday." So
yes, we do get, especially right before Christmas, we get a lot of calls saying, "I have a flight booked. Can I come see you beforehand?" Yeah. So it gets people thinking.
Cool. If anybody's got any questions, you can unmute or just type it in the chat, and don't, no pressure, because I know people have got some personal questions that they're probably going to reach out to you with. So
I can see a couple in the chat. I see Claire asked, "What's the average time taken in BC when the will goes to probate?" It really depends on the registry. So at the minute, it's about 4 months. It has been about 2 months, but it really depends on sort of their workload. Can you give some examples of admin provisions? Yes. So this could be, for example, the power to invest, the power to borrow on behalf of the estate in certain circumstances, the power to hire professionals to deal with whatever needs to be done, the power to deal with your digital legacy. So as a matter of course, we include a digital assets clause in our powers of attorney and our wills. Some digital asset companies or digital companies, so Apple, Google, Facebook, for example, you can actually go online now and appoint a legacy contact. It's really simple to do, so that gives someone the authority to deal with that asset if there's a period of inactivity or when certain events occur. But other companies just want a will with an executor and a digital assets clause. So I would say our admin provisions are quite lengthy. They're probably 2/3 of the document, just so we can take into consideration whatever needs to be done.
Terrific. This is awesome. So I think this is a really good start, and it's a good reminder to those of us who maybe need to make some updates to our wills. And, I know a few people who have got a piece of paper that's their will that they've got witnessed by a friend, and it's like, is that really going to hold up? Or maybe it's now time to spend some money and get that done. Elisa, just out of curiosity, a basic will for someone who doesn't have a lot of assets and wants to just keep it simple and keep things, going in the wrong direction, and having the court, the government control. What's the starting cost for a basic will these days?
So we try really hard to package price our offering and provide fixed fees. So for a will, power of attorney, and representation agreement for a single individual, it's $1,850 plus tax and disbursements.
And that's all of that all together. That's fantastic.
Yeah, we can do it piecemeal as well, but obviously it makes sense to do it all together.
Yeah, that's terrific. Yeah, because the power of attorney, the will, and the representative agreement, I mean, those are 3 big documents to have. And when you think about the fact that you can get most of that done for under $2,000 while you're alive, the money and the stress and the time you're saving your family from having to deal with that afterwards is huge, because it's going to cost way more than that after the fact, right?
Yes.
Yeah. What happens if the deceased has a handwritten will in BC? There we go. Yeah.
So BC is quite liberal with what they allow into probate. We're one of the few places where you can probate on a copy will, as long as you provide evidence as to why the original can be found. We have probated in the office. I wasn't on this file, but I've heard that they've gotten through a napkin with sort of a scribble on it. you just have to prove to the court why it's the last sort of intention of the deceased. So much easier to have a will in place that's registered with vital statistics. But if there are sort of documents that have sort of something written by hand, then we can try our best to get it through, but we can't guarantee it.
A napkin. That's awesome. I mean, there's napkin math, and I haven't heard of a napkin will, so that's
Yes, yeah.
pretty funny. Is it considered a business expense or a tax write-off? So I mean, I would think maybe the corporate will would be a.
Yeah, so sometimes we have produced 2 invoices, so the corporate side of things would be written off, but the general estate planning is not a corporate expense.
Great. Okay, any other questions? I'm sure there's lots, but it's like you're probably going to get some phone calls. So
that's all right.
Okay, fabulous. All right, so I think in the interest of though there's one more. Even if the investment property is in a personal name, so that's is that Hong? What were you saying there?
So if the investment property is in a personal name, no. Sorry.
Yeah, of course. Yeah, there you go. Makes sense. Okay, so that was fantastic. Thank you for that. We're going to take some little segments of this and share it out for our members. We'll have it on the dashboard in the next couple of days, so it'll be, you know, behind the curtain if you want to watch it again. Obviously, for those of you who want to reach out to Richard and Elisa, Bell Alliance, you've heard me talk about how much we love them. Now you kind of getting a sense of why. You know what we're going to be talking about in the new year, more of this kind of cleanup stuff, and then obviously launching into the whole co-ownership pieces and all of the exciting things that is going to bring into fore. So just a couple quick things before we wrap up. December 11th, that's the next happy hour. So it's the holiday happy hour. So it'll be same places as usual, same time, 4 p.m. PST. And we're just asking everybody to bring a food bank donation, and we'll make sure that we get some items to the food bank. So you'll see all the details in the newsletter coming up. That's probably going to come out tomorrow. It's hard to believe that we're talking about December 11th. That's 3 weeks away. It's not even that far. So when somebody reminded me about the happy hour in Mexico, and they're like, yeah, it's 2 weeks. We better make a plan. So speaking of that, we are doing our happy hour in Mexico. So we're growing the WREN chapter in Puerto Vallarta. So Deborah McDonald is down there already. We've got our realtor that's going to be helping us out, where everybody knows we're looking at boutique hotel properties down there. Interesting to hear Richard talking about the Mexicans coming up to Canada as well. So that's really cool. We're all sort of moving around places where it really works out. So that'll be December 4th for your friends in Puerto Vallarta. Couple of other things just to talk about. Again, I just want to mention that while I'm away, and in general, Alexis and Hong, who are actually both on the call, Alexis Kavanaugh and Hung Liu, are our community leaders for Vancouver. So they'll be hosting the Christmas party. Hong is going to be doing Cash Flow Crunch. I'm feeling like we might be doing Cash Flow Crunch on that property, Alexis, that you and I went to see. So we went to see a 9-unit renovated. It's sort of being pitched as a seniors home, but it could be a co-living space. It's a really cool property near Commercial Drive. We really liked it a lot. So we thought we'd run the numbers on it. So we'll probably do that for Cash Flow Crunch. If anybody else has a property that they want to run the numbers on, we've got Cash Flow Crunch on the first Wednesday of the month. And we had a lot of fun analyzing a property last time. So it's always fun to look at different properties and just run through it with a group of people, right? What's the rent? What's the idea behind it? What's the long-term play? And so it's fun to look at simple properties, and it's also fun to look at properties that are quite complex. So that's coming up. And then Darlene and I have been having some great conversations about what's going on in the new year. So we know that there's some coaching requests. So we've talked about the coaching with Hong as well, and with Sherry. Sherry is we're branding Sherry as the wise grandma. So we're talking about Sherry Krause, who's been around for a long time. She's built apartment buildings. She's been a supporter of WREN almost since the beginning. And she really wants to share her knowledge, and she, you know, we've kind of realized that we all kind of look at her as this grandma figure, and so we're going to run with the wise grandma idea around the stuff that she's doing. So lots coming up. Again, if you've got some ideas about what you want to see in the new year, if there's some speakers that you'd like to hear from, definitely Darcy is going to be jumping in, and we're going to be doing some coaching with his newly, well, not so newly acquired, but now that he's really into the neuroscience piece with the Joe Dispenza training, and he's also a certified Mind Valley coach, so he really wants to dive into the coaching. So we're going to be doing some of that as well. So lots of exciting things happening. Please make sure that if you are not subscribed to the newsletter, which I think most people here are, make sure you hop on to the WREN.club website and subscribe. We're making some changes. We're actually moving the site over from WordPress to Kajabi. So it's going to be a little bumpy in the next couple of weeks, but we figured we'd get it done now before the new year. And then we'll get all of our new pictures and new faces and new sponsors, and we'll start getting everything uploaded. So super awesome to see so many great faces here tonight and lots of great questions. And so I guess before I turn it off for the evening, does anybody have anything lastly that they want to share or say or ask? All right, it looks like we're good to go. Terrific. Thanks, everybody. We'll see you next time.
Thank
Bye.
you.
Great to meet you all.
Thank you.